Tonight, we bring you an urgent update that could reshape the lives of thousands of immigrants across the United States. The Department of Homeland Security is reportedly considering a new policy under the Trump administration that would introduce sweeping changes to how green cards, parole, and asylum applications are evaluated. This proposal is specifically aimed at individuals who hail from countries previously affected by the travel ban issued by former President Donald Trump, mostly nations in Africa and the Middle East. The policy draft indicates that U.S. Citizenship and Immigration Services may now treat country-specific factors as significant negative considerations when assessing immigration applications, meaning that merely being from one of these nations could place applicants at a severe disadvantage, regardless of their qualifications, background checks, or contributions to American society. This announcement has sent shockwaves through immigrant communities, particularly among Afghans who resettled in the United States after the Taliban took over their country in 2021. Tens of thousands of Afghans arrived under humanitarian parole or temporary protected status, navigating an immigration system that offered them hope for permanent residence. For these individuals, who risked their lives working alongside U.S. forces or fleeing persecution, the proposed policy could transform their journey towards citizenship into an endless limbo. Advocates warn that it could even open the door to deportation for those who thought they had finally reached safety. Sean Van Diver, president of the San Diego-based nonprofit Afghan Evac, has described the move as an effective travel ban for people already residing legally in the United States. The potential implications extend far beyond the Afghan community. Legal immigrants from other countries on the travel ban list could face delays, denials, or more stringent scrutiny of their applications. This includes individuals who have already passed rigorous background checks and security screenings. Critics argue that the policy undermines the principles of fairness and equality in the immigration system by introducing discrimination based solely on nationality. Under current procedures, immigrants are evaluated on personal history, skills, and contributions to American society. The proposed changes would insert a new, automatic negative factor into that evaluation, a factor applicants cannot control, erase, or mitigate. This policy comes in the context of a broader pattern under the current administration, which has curtailed refugee resettlement and tightened immigration policies since taking office. Earlier this year, refugee admissions were restricted to 7,500 individuals annually, a stark contrast to the roughly 100,000 refugees admitted each year under President Joe Biden. Among the restrictions, priority was given to white South Africans, while many individuals fleeing war, persecution, and humanitarian crises were left without viable pathways to safety. The closure of the U.S. State Department's Office of the Coordinator for Afghan Relocation Efforts, or CARE, removed a critical resource that had supported Afghan allies throughout the resettlement process. Hundreds of staff members working on these efforts were laid off, further limiting options for those already navigating complex legal pathways. The human impact of this policy is profound. Families face uncertainty, with parents unsure if they can remain with their children, and professionals worried that years of contributing to American society could be nullified by their country of origin. Many fear that this proposal signals a shift toward a system that prioritizes nationality over merit, leaving some of the most vulnerable populations at risk. Community leaders and advocacy organizations are mobilizing to oppose these changes, visiting lawmakers, organizing petitions, and raising public awareness of the potential consequences. The stakes are high, as the policy could affect tens of thousands of lives, including individuals who served alongside U.S. forces or assisted with diplomatic missions abroad. The controversy also raises questions about the consistency of U.S. immigration policy. While the country has long positioned itself as a global leader in offering refuge to those fleeing danger, this proposal appears to reverse that trend. Critics argue that it sends a message of exclusion and discrimination, potentially eroding the nation's reputation as a safe haven for immigrants. Legal experts emphasize that treating applicants differently based on nationality contradicts fundamental principles of fairness and equality in immigration law. For decades, the U.S. has allowed individuals from around the world to pursue permanent residence based on merit, family connections, humanitarian need, or asylum claims. Introducing automatic negative factors tied to nationality undermines the core idea that the United States evaluates people as individuals rather than as members of a group. At the center of the debate are the thousands of Afghan evacuees who arrived under temporary programs designed to protect them from immediate danger. Many of these individuals arrived with promises of eventual permanent residence and the opportunity to build a stable life in America. Now, uncertainty looms over their future, as advocates warn that the new policy could leave them stuck in temporary status indefinitely, unable to advance toward green cards or citizenship. Some fear the worst-case scenario, which includes potential deportation despite their service, cooperation, or reliance on U.S. humanitarian programs. Experts describe this as a moral and legal dilemma, raising questions about the country's obligations to those who risked everything to assist American missions abroad. The timing of this proposal also coincides with ongoing political debates over immigration, national security, and refugee resettlement. Supporters of the policy argue that it strengthens border security and ensures that applicants are thoroughly vetted. They claim that considering country-specific factors provides an extra layer of caution, especially when evaluating individuals from nations associated with instability or security concerns. However, opponents point out that applicants already undergo extensive vetting, including background checks, interviews, and security screening, making additional nationality-based scrutiny redundant and discriminatory. The tension between security concerns and humanitarian obligations has once again come to the forefront of national debate, highlighting the delicate balance policymakers must strike. Community organizations are preparing to respond quickly should the policy move forward. Legal aid groups are strategizing on how to assist affected immigrants in navigating the potential changes, while advocacy groups are ramping up efforts to lobby Congress and administrative agencies. Public campaigns are also underway to educate citizens about the human impact of the proposed changes, emphasizing stories of bravery, service, and resilience among immigrants who face the possibility of having their lives upended due to factors beyond their control. In Washington, D.C., the conversation continues among lawmakers, legal experts, and advocacy groups. The stakes are not just legal but moral and political. Observers note that how the administration handles this policy could influence public perception of America's commitment to fairness, human rights, and the rule of law. At the same time, affected communities are bracing for a long legal and bureaucratic struggle, knowing that the proposed changes could take months or even years to resolve fully. Families, professionals, and students who arrived in good faith under legal programs must now face the possibility that their paths to permanent residency may be blocked, delayed, or complicated by a policy that prioritizes nationality over individual merit. As this story unfolds, it serves as a critical reminder of the human faces behind immigration statistics and policies. Every individual impacted by these proposed changes has a unique story of perseverance, hope, and courage. From families fleeing war zones to professionals contributing to local communities, these immigrants embody resilience and determination. Advocates stress that policy decisions must account for the human cost, recognizing that behind every application is a life shaped by extraordinary circumstances and often unimaginable challenges. In the coming weeks, the nation will watch closely as discussions continue, legal challenges emerge, and communities mobilize to protect the rights and futures of affected individuals. Whether this policy becomes a permanent feature of U.S. immigration law or faces strong opposition that prevents its implementation, its introduction highlights the ongoing tension between security, policy, and humanity in the immigration system. The debate underscores a broader question about what America stands for and how it chooses to balance national interests with moral obligations to those seeking refuge and opportunity within its borders. This evolving situation is more than a legal issue. It is a test of values, principles, and the nation's commitment to those who have trusted it as a safe haven. As policymakers deliberate and communities respond, the world watches the United States grapple with the challenges of immigration in an era of political polarization, national security concerns, and global humanitarian crises. The decisions made in the coming months will leave a lasting impact on countless lives, shaping not only the futures of individual immigrants but also the character and reputation of the nation itself.